Welcome to the session on common land and common property resources. So, in this session, we'll be talking about common land, which is little uncommon in land discourse. While this is very common to any village in India or any urban setting, neither in the government administration, policy discourse, nor in practice we heard this word common land very much in India. So either we talk it as public land, government land, or community land, and along with a absence in the legal framework, we also find statistics around common land to be misleading or confusing, and policy and practice and investment on common land are not much. While it remains a fact that for the livelihood of the local communities in rural and urban India, as well as for the ecosystem and ecological resilience for climate action, common land remain very important. So, in this session, we are trying to see if we can provide you with some understanding of what is common land, what kind of common lands are there in India, how the common land is measured, how you look at common land in different policy discourses, and what is going to be the future of common land. So, commons, as the name suggests, are tangible or intangible resources, because we talk to commons mostly in economic and resource perspective, and those resources could be goods and services which are used and managed often by the communities which are local, or collectives which could be local institutions, usually for a shared benefit. So commons can be you can see them from mountains to valleys. This could be forest to the coastlands, and it could be in rustic villages or the bustling towns and cities. And like commoning is not just an abstract idea, but a living practice deeply rooted in ethos of our society. I know someone was telling me that before the word citizen came into existence, we are calling people commoners. So I think commoners are more people who are living with commons, and citizen when state comes in and we provide more top-down kind of approaches. So if you look at common land, so-called common lands, different type of commons in India. So it could be forest commons, which all of us we know, the forests, be it in central Indian tribal belt, or in northeast India, or in Himalayas, western or eastern Himalayas, or the eastern Ghats and western Ghats, where the forest cover is high. And the forest we know, though are controlled by the state with the trusteeship of the nation, but most of the time they are treated as commons for the local communities. We have pasture lands, grazing lands, where no livestock graze, where the pastoralists take also nomadic pastoralists take their livestock across, for example, Western India. We have coastal commons, we have water commons, wetlands, water bodies, and also cultural commons, which we call most of the time. One of the important cultural commons is sacred groves, and there has been a recent Supreme Court decision on that. We'll also discuss about it. So if you look at forest, while we have a nomenclature of forest from a state perspective, like reserve forest, protected forest, village forest, but when you look at communities, community look at forest in different discourses. They have, like, people talk forest about as jungle, aranya, van, in different forms of language, like somewhere in Tamil Nadu it is called Aranyal, Gram Van we call it Gram Van, Ran in some places, Gramya jungle in some part of Khundkatti in Jharkhand. So there are local nomenclatures about forest and the way they interact with the forest. And even within a single forest patch, also we found communities have different name for different forest patches, particularly the way they use the forest, particularly based on some kind of events. The vocabulary around forest, the way community interacts with forest as a commons is pretty high. Similarly, if you look at pastures, they have also different names like Gochor, Garian, different names, and every village, almost every village in India used to be 4 to 5% of land devoted for pasture, and wherever forest is possible, around 10% of land for forest. And these were the land which were providing sustenance to local communities, landless people, particularly marginalized communities, women, not only in terms of livelihoods, but also in terms of food, direct and indirect food sources. Coastal commons, we have like mangroves, we have different kind of systems in different part of coastal ecosystems all across the coast of India. And also in terms of sacred groves, which is one of the important areas of within forest landscape. It could be also in agricultural landscape where people reserve some kind of trees, some kind of wilderness for different uses. It could be as a burial ground, it could be a worshipping place. We call them like Devarais in Maharashtra, we call them Kavu in Kerala, Jahera in part of Odisha, Devgudi, Gompa forest in Assam and Arunachal, Orans and Devani in Rajasthan. So the recent Supreme Court order is around Orans of Rajasthan, which is also applicable to across India. So these are the patches of along forest or wilderness where community through some traditional customs and rituals protect these patches, and they always reflect very rich biodiversity in terms of very many endemic flora and fauna, which are very critical for conservation ethics. So Supreme Court recently, I think this year, has made an announcement that this in respect to, I think, with respect to a case filed by some communities in Rajasthan to protect the Orans, and they have also asked all the states in India to develop a registry of these sacred groves and try, initiate measures to protect them. So if you look at these commons together, though there has been no very contested estimates, but as per one estimate, but particularly by an institution which has been working around commons for long, Foundation for Ecological Security, based out of Anand, that there are about 205 million acres of area, a quarter of India's land mass, are under commons. It could be community forest, pasture lands or wetlands, including sacred groves, and so on and so on. And together these land, water and forest commons meet critical household needs of more than 350 million rural people. So almost 35 crore of people, like almost a little more than 1/4 of communities. They also provide ecosystem services, which could be pollination, watershed services, nutrient cycling services to the tune of $90 billion per year. And a commons which is ecologically healthy is critical for natural functions, for surface and groundwater, for soil nutrient, for carbon sequestration, for pollination and pest control, as well as they also provide rich products like food, fiber, medicines and income. However, these commons are being rapidly degraded because of different reasons, and if you look at one of the statistics which measure common land through different kind of classification, which we call ninefold classification of Food and Agriculture Organization (FAO), where we look at commons as forest, pasture lands, land under miscellaneous tree crops and groves, and as well as cultivable wastelands and fallow lands. We see extent of common land that has decreased. There has been decadal census around this kind of land use classification. So from 51 to 2011-12, we see a substantive decrease in the common land. For example, the pasture land between 1968 and 2017 shrunk from 13.8 million hectares to 10 million hectares, where every village used to have 4 to 10% of common land. Now many villages, pasture land, now many villages don't have this pasture land. So not only these commons are also declining in terms of area, they are also degrading in terms of their reproductive capacity, in terms of ecological resilience, and also getting disconnected from local communities. And there is also another important discourse which is influencing this common land decline. The discourse is of wasteland. So this wasteland discourse started in 1985 when from a productivity viewpoint, Government of India thought that there are a lot of land lying waste from an economic productivity perspective, and they must be put under productive use. So National Wasteland Development Board came up, and a lot of estimates were made around wasteland, which varied from 83 million hectares to 185 million hectares. And while Rajiv Gandhi was Prime Minister, it was being discussed that every year 5 million hectares of wasteland will be developed, and accordingly many watershed programs, joint forest management programs started. And now also more than 10% of land mass are labeled as wasteland. But if you look at this whole discourse of wasteland, it is a purely colonial legacy. Colonial masters, the land which was not giving any revenue for them was treated as wasteland. Till 1857, for the East India Company, almost 40 to 50% of their income was coming from land revenue, and they were collecting land revenue from mostly agriculture land, from land which were under habitation, land which were under forest, which are under pastures. Not much revenue was coming. Of course, after latter they put forest into revenue production through timber best management, through scientific forest management. But the land which were not getting them revenue, they treated them as wasteland. So these lands were not waste ecologically, not waste socio-culturally, but just for revenue perspective, they made it designated them as wasteland, and that wasteland nomenclature continued post-independent, and also now colonized the imagination of policymaker and researchers alike. And this discourse also come from the English common law, which in 13th century referred to land which is not tapped as per its commercial potential as wasteland. So therefore, this wasteland is a purely economic and market discourse which is not taking care of socio-cultural and ecological use of land, and as a result of which putting most land into wasteland. So most of the commons are treated as wasteland. So that's why these common lands are always given for other productive use. It could be industry, it could be giving for agriculture to landless people, it could be for mining, it could be for renewable energy now. While this discourse is going on, as I was referring in the beginning, in government policy and legal definition, common is not defined legally. So either we call them as government land, public land, or community land. For example, when NSSO tried to estimate common land in 1980s, National Sample Survey Organization, they could not find any common land legally. So they took the proxy of this ninefold land use classification, and also proxy of looking at land records where some land are called community land or gochar land or forest land, and taking that proxy they had estimated this common land. When you look at the common land, however, in terms of the way community use, we see a bundle of rights. For example, the common lands are not owned by community. So it could be owned by community institutions, but the institution cannot sell this land like private land. So there could be some right to enter or access this land. There could be some right to extract some product out of the land, right of extraction, like fruits. You can collect fruit from forest, collect fuel and fiber from forest. Right to regulate the internal use pattern. For example, panchayat telling charai bandi or kurad bandi, controlling those kind of things. And also right to determine who will have access, who will not have access, like who can get. So if you look at the way common lands are governed, they're pretty complicated and governed under a principle called tenure continuum, where bundle of rights instead of a only private right of ownership and alienation exists. While in Indian Constitution, the common lands are not clearly defined, neither the rights over them are indicated, but however, the directory principle of state policy, which outline the socio-economic goal of the state, which is not enforceable by the court of law, talk about indirectly and directly about commons. For example, Article 39A talk about that every citizen, men and women, equally have the right to an adequate means of livelihood. That means people can access common land to have the 39B is more particular about that, which talks about the ownership and control of material resources of the community are so distributed as to best serve the common good, so that people have equal access to common land. Article 39C also talk about the operation of economic systems that should not result in concentration of wealth, so that common land should not be encroached for the private purposes. We'll also refer it to a Supreme Court regulation around that. Similarly, Article 40, 46, 48 talk about protect and improve the environment and safeguard the country's forest and wildlife, and 51C. So there are some articles we talk about directive principles of state policy which you people can refer. Similarly, Indian courts have also been giving very interesting judgments towards protection and conservation of common land. So there has been very interesting judgment by Supreme Court as well as National Green Tribunal as well as High Courts. Some of the key decisions of Supreme Court, like in 2013, Supreme Court has affirmed that, particularly in the case of Dongria Khans, in their fight over bauxite mining land in their areas where they have their Dongria's god live in these mountains, and these mountains were rich in bauxite. And when Vedanta wanted to mine that, there was a Supreme Court case where Supreme Court ordered that free and prior informed consent of the community needed to be taken before the land is given to the company, Vedanta. And then Supreme Court appointed a High Court judge to go to these 11, 12 villages. They were on these mountains, these Dongria Khan villages. And the High Court judge went there, and in some villages even there were only 10 to 11 households. And in those villages there was discussions with these communities, and all the villages told no. And as a result of which, the mighty company like Vedanta could not take over the common land of these communities. So this is regarded as a very watershed judgment. In 2011, this court highlighted the critical importance of Gochar land for the rural communities, stating that dereservation of Gochar should be the last resort. So first, all other lands should be given whatever available for diverse purposes for industry or mining or real estate or urbanization. But Gochar land should be the last resort for transfer. Similarly, NGT has also emphasized how when urban planning, town planning is taken up, there should be adequate open space, recreational grounds, and parking facilities that should be providing rights to the local communities. So in urban areas also commons need to be protected. Similarly, NGT also talk about how this Biological Diversity Act is to be implemented by the panchayats through biodiversity management committees and the plant biodiversity registers to protect the commons biodiversity in the villages. However, among all the Supreme Court judgment, one judgment which stands out and talk about commons jurisprudence is Jagpal Singh case, which was started from a village in Punjab, and as a result of which Supreme Court decided that all the common lands where there has been encroachment by private individuals powerful, which is the case in most of the villages, should be evicted. This all the encroachment should be cleared, and those they are encroaching, they should be evicted. However, while this eviction is carried out, if there is some landless, Dalit and marginalized communities are living there for their livelihood, they should be protected. So as a result of that, there has been substantive implications. Many states have carried out these orders. High courts have brought in a lot of supporting judgments, and these are led to protection of commons to a great extent. Similarly, recently Supreme Court also talked about when renewable energy projects are coming up in Gujarat, Kutch. I think this in 2024 only April or May, Supreme Court came up with a decision that there is also a right of life against adverse effects of climate change. And towards that, they are also talking about how to protect commons, how to protect Great Indian Bustard, biodiversity. So these kind of rulings provide very interesting framework how commons can be protected, though they are not clearly defined, but they can always be interpreted to use commons. But what is happening now, that for climate action, where you're talking about to address the issues of climate change and reduce this greenhouse gas emission, we are talking about climate action where we are talking about changing land use, we are talking about building in renewable energy investment, taking up afforestation. So, for example, globally, there estimate that 1 billion hectare of land will be required to address the issues of natural climate solution. In India, about 13% of total land area will be required for 6 climate action. So, and most of the land will be common land. And these common lands, because they are not very clearly defined and treated as wasteland, continue to treat wasteland despite many of these legislations and many of these court verdicts, they continue to decline. most of the investment, if you look at globally in India, has come on common land. Like most of displacements are around common land. So there was estimate that between 1951 and 95, almost 60% of the 1 million hectare that went for development were common property resources. So most of the bigger industries, mining has come up on the common land, and this common land has gone from the community control towards industrialization for most productive use. So this debate of protecting common land and diverting common land, treating it as a wasteland for more competitive use continues. But as citizens, as commoners, as students, we need to look at how we understand this common land beyond all these narratives and go deeper, looking at how common land policy should be formed, how local institutions like Gram Panchayat, for example, if you look at PESA Act, which came up in 90s as part of decentralization and democratization of natural resource governance, and the village council in Northeast, how this decentralized governance control commons also need to be looked at. And in that context, when you decide about this role of local institution, frame common land policies, we must look at also the tenure continuum. And one of the future direction towards common governance could be bringing in a kind of national legislation in the line of Forest Right Act, drawing upon the Jagtap Singh order. But at the same time, we also see how technology, how data also can be used to monitor commons and provide these communities at village level a tool to protect their commons. I hope you had a good overview of how the common land is defined in India, how looked at in policy, and how the policy and the legislations are legal framework try to address, despite the fact that common land is continued to diverted. And I hope it will be useful for you. Thank you.